Good morning. We're here for oral argument in our cause number CACV 130118, State of Arizona versus Jones. These proceedings are being audio and video recorded, so we would ask you to identify yourself and your client. Each side will have 20 minutes. To the extent the appellant wants to reserve time, you'll be responsible for doing that yourself. We have read the briefs and we've conferenced this matter earlier today. And with that, counsel, you may proceed.
Thank you. May it please the court, my name is Rhonda Elaine Neff, and I'm appearing on behalf of the appellants in this case, Kevin Jones, Morel Jones, and Jones Brother Transport, LLC. I'm also appearing on behalf of Clark Derrick, who was the attorney in this matter, who is out on a surgery today, so he apologizes for not being here. With me today, sitting to my left, is my assistant, who is here just to assist me today. I want to start, well, first let me reserve 5 minutes for rebuttal, if I may. I want to start, I think the gut of this case in what the issues here on appeal are really fall into three categories. One is whether or not the 10-day notice language in ARS 134311G is a grace period or whether it is superfluous language. The next is the ability of excusable neglect to apply to the forfeiture statutes where there is no other procedure for getting out of a default under the forfeiture statutes. And finally, whether the jurisdictional requirements of a claim as set forth in the forfeiture statutes apply to an answer as well, whether essentially you have to verbatimly restate your entire claim as part of your answer. So starting with the issue of the 10-day notice, it's the appellant's position that the order issued by the trial court in this case is void because the state had failed to comply with the 10-day notice requirement. And the language actually in 134311G indicates that there is a requirement of a 10-day notice to any person who's timely filed a claim. There's no dispute in this case that the appellants timely filed a notice of their verified claim with the court, and there's also no dispute that the verified claim that was filed in this case complied with all the requirements of 134311.
But let's cut to the chase and talk about Anthony, because it's the elephant in the room, and to adopt your position we would have to disagree with Anthony. And why would we do that given its explanation of potential purposes of the 10-day notice separate and apart from a grace period?
I think Anthony does play a role, but I think particularly in this case, the state didn't have the luxury of the Anthony opinion when they failed to supply the 10-day notice. So in order for the court to apply Anthony to the facts of this case, you as a court would have to agree that the Anthony opinion, which is a District 2, Division 2 opinion,
it's Division 1. But
is it? Oh, I'm sorry. Is applied retroactively to this case.
Well, it was applied to the Anthonys.
It was applied to the Anthonys, and I understand that. The appellants have argued, and I think that the explanations as set forth in Anthony for why the 10-day rule applies, I think what the Anthony opinion doesn't do is establish what the interlink is between the rules of forfeiture and the rules of civil procedure. And the Anthony opinion specifically is looking at what other possible conclusions there could be why the legislature would include the 10-day language in the statute. And it sets forth, I believe, three or four additional reasons why the legislature could have put it in there. One is just to put everyone on notice, hey, within 10 days I'm issuing an order. But when you look at that in conjunction with the rules of civil procedure, the language is almost identical to that required under the default judgment rules requiring the 10-day notice. So it's the appellant's argument that the Anthony court looked at it in isolation as just under the forfeiture statutes and didn't look at it in light of the interpretation under the rules of civil procedure.
Don't the rules of civil procedure specifically reference being able to set aside the default?
Yes, they do.
Isn't that very different than the than the forfeiture statute?
I don't believe so. The reading of ARS 4311B particularly states that the forfeiture statutes are governed by the rules of civil procedure unless there's a procedure otherwise. So where the forfeiture rules lack a provision or a procedure otherwise for the ability to set aside a default, I believe under 4311B that then becomes governed by the rules of civil procedure, particularly in light of the judicial system as a whole favoring finalizing actions based on the merits versus on technicalities of procedure. And while I understand that the 10-day notice period, could be up in the air, I still believe even if the court were to look at that and say, okay, well, Rule 55, the rules of civil procedure, don't apply, because if they wanted to have a way to set it aside in the forfeiture statutes, they would have included that. Well, then why did they include the rule that says that it's governed by the rules of civil procedure in the absence of any other procedure as set forth in the forfeiture statute?
It's a procedure that's set forth in the forfeiture statute.
The filing of the actual application for order of forfeiture is set forth in the forfeiture rules, but there is no procedure in the forfeiture rules on how that's handled upon issuance. And so to read the forfeiture statutes in isolation on that issue, I think does make the requirement of the 10 days superfluous, and I think it's difficult to argue that the legislature would put a 10-day notice requirement in there, particularly calling it a notice requirement, if in fact it didn't serve a purpose of putting somebody on notice with an opportunity to cure a defect.
So, Counsel, just to come full circle, so following up Judge Downey's initial question, you are suggesting then, or at least recommending, that we would have to overrule that portion of the Anthony case, or disagree with. We can't overrule it. Can we? How could we get to your construction of the statute unless we specifically disagree with the Anthony case? Is that?
Well, I think we are arguing that the Anthony case was wrongly decided on that particular issue. And I don't think it's that the justices themselves made a wrong decision. I think it's that the issues before the court at that particular time were not dealing with the interplay of the rules of civil procedure against the rules of forfeiture. And so while, yes, I believe the court would have to disagree with the Anthony decision and its ability to retroactively apply to this case, but I think that the grounds to do that is the issue before this court has been raised in the interplay of the rules of civil procedure with the rules of the forfeiture procedures. In addition to that, I think that when you look at Anthony, which didn't specifically overrule State v. Jackson, I think we are in a much similar position in this case in State v. Jackson, where the court throughout State v. Jackson comes out on multiple occasions and without setting out it as a grace period refers to it as a grace period.
CR Jackson as being more in the form of dicta, just saying they didn't file something within the 10-day period, whereas they seem to be specifically addressing the issue in Anthony. So it seems like there's dicta in Jackson, but then we have a specific ruling in Anthony.
I would agree that most of the language under State v. Jackson does fall into dicta. In Jackson, I think the big issue for there fell in that the state had actually provided the 10-day notice period. They acknowledged there was a 10-day notice period. And in that case, they failed to file their answer during that 10-day grace period. And that was the issue that went up before the court is what's the opportunity for default if you haven't filed the answer within that 10-day period. Currently, up until this case, the forfeiture agencies have been applying it as a 10-day grace period. We have been receiving notice and opportunity to cure. So this is, and this was, and that's why I think this case has such a big impact on the application of the forfeiture statutes, is because I think it is unclear how you interrelate the rules of civil procedure with the rules of forfeiture procedure. And State v. Jackson, while they do mostly in dicta come out and state one way or the other, with this grace period, they do specifically point out that the appellant failed to answer the state's complaint after receipt of the 10-day letter, indicating that at least the court at that time had considered that as a 10-day grace period. The issue that came up in Anthony was a little bit different than that of Jackson, and I think that the facts underlying State v. Jackson are much more on point to the facts that we have in this particular case, where there is no dispute that a verified claim was filed. There's no dispute that it complied with the rules. There's also no dispute that it gave the government proper notice of what the interest in these claims was, and it was verified properly. And so even if the court were to find that the 10-day notice period wasn't complied with for the order, we still have an issue of whether or not the court should have allowed the appellants, in this case the claimants, to go in and amend their answer to conform. That is an argument of substance over procedure. And, you know, we are looking particularly at cases like in re matter of 70,269.91 in U.S. currency, and you're dealing with, you know, the two substantive requirements in that case of the statement of the interest in the actual property signed under oath, and whether the timely claim was filed. And I think that's important, because the claim is what puts the government on notice under the forfeiture statutes. That is what sets forth who has an interest in what. So the filing of an answer would seem that it would fall more under the rules of civil procedure in its actual application, what its purpose is in responding to an actual complaint. If you took the state's argument on that, then we would be required under the plain reading of the statute to say that, okay, well, if it must comply in all respects then to the verified claim, then you would have to take the verified claim, verbatimly write it back in the answer, and then go through each one of the allegations in the answer or in the complaint, and do it as an answer, because it does say that the answer is filed as stated in the rules of civil procedure. I think having that interplay between the two is what's causing the confusion with which one applies and to what. I do think that Rule 4311B added that the forfeiture statutes be governed by the rules of civil procedure in the absence of a procedure otherwise, based on that very reason. An in rem procedure suit is in most respects a civil suit. It's filed as a civil suit, is preceded as a civil suit. Most of the people that practice in this area are civil litigators, and so I think interplaying that, I think that language was specifically included, and I think it was included for situations like this where a court could have the discretion to follow under the rules of civil procedure unless something was jurisdictionally set out in the forfeiture statute. In this case, the only thing that's specifically set out as a jurisdictional requirement is the timely filing of a verified claim. It doesn't say under the answer statutes that that's jurisdictional, that if you don't have a verification to it or if you don't timely file it, you lose your claim. It does specifically state that under the notice of claim requirements. In addition to that, you also have an issue where there is confusion in what's the answer and what's the claim here. I understand the appellee's argument that it could have just been the court getting terms mixed up, but those terms become vitally important under a forfeiture statute, and they become vitally important in the opinions and the issues here on appeal. Benson is very favorable to us on the issue of the answer, and that's because Benson applied specifically to claims. It didn't apply to answers. So the order in Benson indicated, or sorry, the court in Benson indicated that if a claim was filed but was substantially, in all respects, compliant with the statute, a court had discretion to allow amendment, so long as it met the substantive requirements. Well, if you can amend a claim under the court's theory in Benson because it was defective, then it would seem to reason that also you could amend an answer that was substantially compliant. And in this case, the only real non-substantial thing, and we argue that it's procedural, was the filing of the verification. Now, the verification, the statute does indicate that you have to have it signed under oath by the party claiming an interest. But that particular provision is meant to put the state and the government on notice of whose interest is there. In this case, that's why we argue that that's a procedural requirement. That had already been done. There was no dispute as to whose interest was what, because the verified claim had already been filed. The state was already in possession of that. They knew who was asserting a claim in that property because they then served us with a notice saying, okay, now here's my complaint that I'm required to file because you guys have indicated an interest. So there wasn't confusion on them as a party. So I do believe that the court should have allowed the leave to amend to include the verification. Going further on the issuance of the jurisdictional requirements, I think it's important to note where the legislature includes particular language and where the legislature does not include particular language. And the statute indicates that an answer must comply with all of the requirements of claims. But again, if you take that on its plain reading, then that means that there really is no purpose in filing a verified claim because your answer is going to be a duplicate of your verified claim under the appellee's interpretation of that statute. In addition, 134311 D, E, and F are substantive requirements rather than procedural, but G doesn't bar extensions of F. And I know that's just throwing out a whole lot of numbers here, but the jurisdictional requirements listed in the forfeiture statute themselves are in conflict with one another and would seem to indicate then that you would govern that under the Arizona Rules of Civil Procedure, which are liberal. You get liberal reasons to amend so long as the state's not prejudiced. And this is a great case to be able to showcase that the state was not prejudiced. The complaint was filed 2 days late. They were on notice of the interest. They were on notice of the parties. There was no prejudice caused to them by the 2-day delay in the filing of an answer.
Could I ask you, was there verification filed on behalf of Jones Brothers?
Your Honor, the verification was filed on behalf, was signed by Merrill and Kevin Jones, who are the sole owners of Jones Brother Transport. And if the court doesn't mind, I'd like to reserve my last 4 minutes.
Realized I'm too tall to see. May it please the court, my name is Tom Stockson. I'm a deputy county attorney with the Yavapai County Attorney's Office, and I represent the appellee in the state of Arizona. 134311G has 3 substantive requirements for answers. The first being, it must be filed within 20 days of service of the state's complaint. The second is that it must be verified under penalty of perjury. And the third is that it must comply with all requirements for claims. The answer filed by the appellants in this case failed in all 3 respects. As such, 134311G instructs the state specifically as follows. It says the state shall proceed, if no proper answer is timely filed, the state shall proceed pursuant to 134314 and 134315 with 10 days notice to the claimants.
What is the point of the with 10 days notice, if not to provide a period to cure a default?
Well, first of all, the Anthony case does list several reasons why it's not a curative period and gives several reasons why that 10-day period is there. I won't repeat those, but I will add a few more. One possible reason for that 10-day period is if the state looks at the answer or determines there's no answer, files its application, it does give a period for the claimants to say, wait a minute, court, before you rule on that, I filed my answer timely, or my answer was properly verified, or my answers complied with the claim requirements. And in fact, the claimants in this case did 5 days later file a response and say, hey, our claim was timely. Their computation of time was wrong, but they did in fact use that 10-day period to prevent the court from ordering, to try to prevent the court from ordering judgment. Unfortunately, they were wrong on the law with respect to that point. The 10-day, the state in this case filed its application for order of forfeiture. That order was granted. And now for the appellees to ask the court to overturn that, they're really asking the court to ignore the plain language of the statute, ignore the plain language of the rules of civil procedure, and of course, ignore the Anthony decision, which they claim.
Counsel, let's go back to your comment about the plain language. Let's just focus on because I think that that's one thing that the Anthony case does not do is is really engage in a fair discussion of the plain language of the statute. Again, following up on Judge Catani's question, with 10 days notice to any person who has timely filed a complaint, a claim, with 10 days notice to any person. So does that mean all, doesn't that mean all persons? What is the plain language of the phrase, with 10 days notice to any person who has timely filed a claim?
Well, it lets the parties in the forfeiture action, and oftentimes there's more than one party filing a claim. You could have, for instance, there could have been a lien on the semi-tractor, which was part of this forfeiture action. We could have had a claimant or a claim filed by the lien holder. They would get notice. And the Anthony decision actually addresses that. It says one of the purposes for the 10-day notice is to give non-defaulting claimants, those were other people who have filed claims, an opportunity to appear and protect their interests once they know the state is moving forward. Another example would be
well, I understand that those are purposes, I mean, valid purposes of the statute, but usually when we interpret statutes, we don't go to the necessary to determine the purpose, the background, the actual effects. We don't look at that in that if the plain language of the statute is clear. And are you saying it's not clear? I mean, it's ambiguous, or maybe it is because it says with 10 days notice. What does that mean? 10 days prior notice?
No, it doesn't. The Anthony case, I think, correctly says it's with the 10-day notice is given with the application for order of forfeiture, which is what the state did. The 134311G, if you look at the forfeiture statutes in whole, they're an expedited process to deal with property interests, because not only do you have interests of the wrongdoers, you have interests of lien holders, innocent parties, things like that. So the statutory scheme is set up for an expeditious resolution. You can see that through the statutes. Under 134304.3, it says notice of seizures to be given as soon as practicable. Under 4311E, it requires claims to be filed in 30 days with no extension of time. Under 43G, it has the 20-day period to answer and a reduced period in which to file responses to discovery. Under 4311K, it provides the trial court, or requires the trial court to have a trial within 60 days upon completion of discovery. So this whole statutory scheme is an expedited process. 134311G is consistent with that and very similar to the claim deadline under 134311F. When a claim is not timely filed under 134311F, under the statutory scheme, you go to 134314. That's the procedure for filing an application for order of forfeiture when no claims are filed. Likewise, the legislature intended the exact same result when there is no timely answer. It directs the state to proceed pursuant to 134314G. So it's all part of a comprehensive expedited process.
I don't want to belabor our discussion on Anthony, but you've noted that Anthony sets forth some reasons that are unrelated to a grace period. But in your view, if you were arguing Anthony today, which of the reasons cited in Anthony do you view as being particularly persuasive?
Well, I would argue the reason. The reason I gave that it allows a claimant to say the state is wrong is certainly a good reason. I have in fact filed an answer. Yes.
Okay. Any other particularly compelling?
Well, you have to remember these forfeitures can happen in a variety of different ways, and probably the most important thing is to give a claimant who has failed to file an answer, and it's not uncommon for claimants to file claims but decide later on not to file an answer. Kevin Jones in this case pled guilty shortly after filing his claim. He had ample reason not to timely file an answer because he's basically stopped from denying the underlying allegations in the criminal defense or in the criminal case in this forfeiture. So it's very common. So You may have a constructive seizure where you have a claimant who is still residing in a house subject to forfeiture, or a claimant who's still operating a business subject to forfeiture. If they don't file an answer and the state proceeds this way, that 10 days notice is helpful to those folks to let them know that things are going to change. You're either going to have to vacate the property, you're going to have to wind down the business because the state is moving forward now that you've failed to file an answer. Now, counsel for the appellant said the state is, in their opinion, often allowing a curative period. In my experience, and I've been doing this for 16 years, I haven't been allowing a curative period, and I've talked to many other folks who operate in the forfeiture arena throughout the state. I don't think that that is happening, or certainly isn't the majority position. I'd like to address their
What is the harm to the state, though, and if an answer is filed a day late, 2 days late? Why go forward if someone just made a calendaring mistake and it gets filed, say, 6 hours late, it's filed the next day?
Well, as I said before, it's an expedited process, and the other problem was it's just not a late answer here. It lacks in all the substantive requirements for answers. It's late. It's not verified.
But if we're just talking about is this rule automatic, and assuming all the other things were properly verified, everything else we're taken care of, would that still be the policy, you think, statewide, if they're 1 day late with an answer?
Well, if you look at the Ochoa case, which was cited, which deals with claims, Ochoa says a claim 1 day late is too late. And as I said, 4311G acts very much like 4311E, which is the 30-day deadline for claims, and it's consistent with that. The difference between the claim and the answer is, I believe the claimant has the opportunity under Rule 60C to come back and address the late answer if they choose to do so, if they can establish excusable neglect.
But if you could get past the timeliness of the answer, don't you think Benson provides some support, even though it's under the claim issue, for the notion that leave to amend could be granted as to a timely answer?
No. And here's why. Benson says this. They looked at the claim, they said, well, if you want to amend a claim, you at least have to hit the substantive elements of a claim. Now, under 134311G, an answer must comply with all the requirements for a claim. So in Benson, they found if the claim doesn't substantially comply, if it's not timely filed, if it's not signed under penalty of perjury establishing an ownership interest in the property, then leave to amend is inappropriate. And that's the situation here. We have an answer that's not verified, doesn't meet the claim requirements, and is late. So under the Benson analysis, if you apply that to the answer here, the answer is no, leave to amend is not appropriate. The claimants allege that the claim requirements is just a repeat of what was filed in the claim in the answer. 134311G requires them to comply with the requirements of claim, which would again require them to go through the elements of 134311E and hit those claim requirements. It's not a repeat, and here's why. The facts in this case changed substantially since the claim was filed. Mr. Jones filed his claim and then within 10 days pled guilty to the underlying criminal conduct. That's a game changer in forfeiture. He now has to explain in the answer why he still has a claim in this matter. Not to mention, neither Kevin Jones nor Morel Jones made any claim to the $8,000, which is at issue here on appeal. Another factor that can come into, well, and that's another reason why the state would want, or why the statute requires the answer to go through the claim requirements again. The state filed its complaint. It laid out its theory of forfeiture. It requires the claimants now to look at their claim and reconsider under the state's theory of forfeiture. Are they still exempt from forfeiture? do they have a valid claim? The state pointed out a variety of things in its complaint. It pointed out that Morel Jones and Kevin Jones are husband and wife under 13430105. Kevin Jones's conduct bound Morel Jones. The state pointed out that Kevin Jones wore all the hats in the corporation. Kevin Jones' conduct bound the corporate conduct. So things have changed from the time of the initial filing to the claim of the claim. The state then files its complaint, laying out its theory of forfeiture. That's the opportunity for the claimants to reevaluate their situation and reevaluate whether they can continue as claimants
On that
in this
point,
forfeiture
forgive
action.
me for not recalling exactly, but I know that there were 3 categories of property. There was the semi-tractor trailer, there was the cash that was on the persons who were stopped that day, and then there was the bank account, which is what remained at issue. Did the claim initially relate to all 3 categories of property? I'm just trying to flesh out
It
your
did.
argument that things had changed. I'm curious whether, in fact, there was a difference, because now we're only fighting over the $8,000 in the bank, and the other 2 have fallen away.
Well, my reading of the claim is that various people, Kevin Jones, Morel Jones, Jones Brothers Trucking, made claims to various pieces of property, but they all did not claim all of the property.
But your point is, after his conviction, then he couldn't legitimately make a claim as to certain aspects of the property that might have been in play prior to his conviction?
Well, I think he certainly has to reconsider his position in light of his claim. And by the way, he actually agreed to forfeit most of this property in this plea agreement as well. So I think that is an opportunity for the claimant to go back and reconsider. And as I said before, the state laid out its theory of forfeiture and provided some detail as to why this property is subject to forfeiture when the state filed its complaint. And that's an opportunity, and I think the statutory scheme properly requires a claimant to reconsider their position.
Are you saying that he disclaimed any right to the property other than the $8,000 before the 10-day period, or before the state then decides to proceed? When did he say he was only he was not interested in some of the assets?
He filed his change of plea on March 20th of 2012. The state filed its complaint April 12th of 2012. The change of plea, Kevin Jones gave up his interest in the semi-tractor and the cash that was on Mr. Jones and his co-defendant at that time. I don't believe the $8,000 was part of the plea agreement at that point. Claimants have raised a lot of issues in this case, and actually I think you can decide this case without even going to the Anthony decision. As I said earlier, there's issues of whether Kevin Jones and Morel Jones even made a claim to the property. As such, they're done at that point, and the answer really isn't relevant.
Following Jackson, just again, I hate to belabor Anthony, but if I had just read Jackson alone, the paragraph in Jackson that's arguably dicta seems to suggest, well, they didn't file an answer after the 10-day notice was filed. It seems to suggest that it's a grace period. Was that the state's understanding after Jackson that there was a grace period, or you think that was just dicta, that was never?
No, the state.
Your view of
the state hasn't taken that position, and quite frankly, with the folks I work with in forfeiture, we have all been kind of working towards an Anthony-type decision to get the resolution that we got in Anthony. Here's the deal. 134311B says the rules of civil procedure apply unless a different procedure is provided by law. If the legislature had wanted a Rule 55 default to apply, they would have written 134311G without the provision that says the state shall proceed if no timely answer or proper answer is timely filed, they would have gotten rid of that. They would have gotten rid of the 10-day provision, and then you would have been left with no mechanism, statutory mechanism, to deal with the default answer, and you would have applied Rule 55 under the rules of civil procedure. The legislature didn't do that. They provided a different mechanism. They said the state don't default pursuant to Rule 55. Well, they didn't specifically say that. They said proceed now pursuant to 1343.14. It's the functional equivalent of a default. It's just not a Rule 55 default. And the legislature has done that in other areas of the Arizona statutes. So I don't think that had the legislature intended this to be a curative period, they either would have not put that language in at all and allowed the Rule 55 default, which, by the way, is very comprehensive and specifically outlines a curative period. 4311G does not. If the legislature wanted that, they would have either specifically put that within 134311G or taken all that language out, leaving the Rule 55 option. So it is not a curative period. There is no statute that I'm aware of in the forfeiture statutes that make it a curative period. And so for that reason, it is what it is. It's just notice, but not a curative period.
Could I just clarify something from the record? There was a request for fees below. Was there a renewed request, or were fees ever awarded to the state?
No, not below. The state actually received its order of forfeiture through this functional default under 134311G. So fees were not requested at that time. I'm just about out of time, so if anyone has any other additional questions. Thank you.
Ready for me to proceed?
Please.
I want to address just a couple of the quick points. One on the standing issue as far as Kevin and Morel Jones's claim. They did file a claim on behalf of their company, of which they're sole owners as husband and wife, of Jones Brother Transport LLC, which is who filed the verified claim on behalf of the $8,000. Quickly to address the plea agreement as it relates to disclaiming the interest in the semi-trailer and the cash on his person. Oftentimes in these plea agreements, we as attorneys do things specifically for a reason. And in this case, there is a valid meritorious defense to the $8,000. There was evidence pointing to a source outside of illegal conduct. And that's one of the requirements for the claimants to be able to prevail on a forfeiture suit, is to be able to show that there is no nexus between the illegal conduct and the property sought to be forfeited. So the property that was directly linked to criminal activity, under the plea agreement, he agreed to forfeit. He preserved the claim to the $8,000 for which there wasn't a nexus to the criminal activity.
Doesn't that highlight that there was a difference, and there is in fact a reason to file an answer as opposed to just saying the state's on notice based on the original?
Absolutely. I think there's a reason to file an answer, and the claimants did file an answer. The question is whether the answer that had to be filed, whether the verification of that was a substantive requirement of the filing of the answer versus a procedural requirement after the overall claim had already been verified as to the interest in the property. At that point, the state was already on notice that they were claiming an interest in the $8,000. So the claimants did file an answer as it related and addressing all of the allegations set forth by the state in its complaint. Now, it was filed 2 days late, and that's part of the argument of the appellees in this case, is that the fact that it was late and the fact that it didn't have the verification automatically doomed the claim. Well, as long as the state was on notice I think that there is an argument that excusable neglect here fits in. It did substantially comply with all of the requirements of an answer. The claim didn't just substantially comply when the verified claim was filed. It fully complied with the requirements of a verified claim. So absolutely, I think that there's a reason to file an answer. And in this case, the claimants did file an answer. I think the real issue is whether the ability for them to come in and seek leave to attach a verification to the back of it upon realizing that there was an error in that, or upon being able to get in touch with the client, falls under excusable neglect and the ability for a court to amend. I'm running out of time quickly, so I do want to talk about the fact that the language, particularly as it relates to the claims, specifically indicates that no extensions of time are allowed. It doesn't say that under the answers. It doesn't say that under the provision that requires the filing of an answer. If the legislature intended you not to be able to obtain leave to amend under that particular area so that excusable neglect wouldn't apply, they would have specifically included that jurisdictional substantive language within the statute under filing of answers as well as filing of claims. And I believe I'm out of time, so that's... Thank you.
All right. Thank you both, counsel, for your arguments. We will take this matter under advisement and issue a decision in due course. Thank you.
Well, at least it's a nice day to be driving. Yeah. It was nice meeting you.
Oh, nice to meet you.
Stick my shoes in. Oh. Is that what you do with your high heels? Is hanging out of your heel? So awesome. Appreciate it. Thank you.